G'day everybody and welcome back to Laws 13010 Evidence and Proof. I'm Anthony Marinac and this is the Topic 8 lecture on admissions and confessions. You'll remember that last week we spent our time looking at the rule against hearsay, and I indicated that there were a number of exceptions to the rule against hearsay, and we looked at some of those last week relating to the use of evidence in relation to credit. This week we go on and look at another of those key exceptions to the hearsay rule relating to admissions and confessions. So what we're going to do is start out by looking at what admissions and confessions actually are and why they should be an exception to the hearsay rule. We're going to look at how you make an admission or a confession. We're going to look at the conditions under which an admission or a confession is binding, and we'll look at how judicial discretion affects the use of confessions in criminal trials. So let's get underway. An admission is a statement by a party that is contrary to their own legal interests. So an admission happens where somebody outside the court says something which tends to indicate either that they should lose the case or that some aspect of the case should go against them. So for instance, if you were being taken to court because you had refused to pay an invoice, saying to a friend outside the court over coffee that you did agree to pay the invoice when you first took the product or service might be an admission, because you can see that it's a statement which is contrary to your own legal interests. It means that you have made a statement outside the court which it seems only fair that the other side is going to be able to refer to when they come to take court action against you. The rule is quite simple. An admission is evidence against the person who makes the admission. This comes from an old case from the 1840s called Slattery and Pooley. The case itself is not that interesting. It was a case about electoral fraud, but the statement within that case that has become the classic statement, the classic description of admissions, is that whatever a party says or acts amounting to an admission is evidence against himself. And it's been rewritten under the Uniform Evidence Act jurisdictions as a simple statement that the hearsay rule and opinion rule do not apply to evidence of an admission. So an admission, quite simply, is a statement that is made by a person outside the court and is contrary to their own legal interests. The word confession, on the other hand, actually doesn't have a specific legal meaning. The thing is that it has become so commonplace that it almost becomes a rule that people use the word confession to differentiate an admission in a criminal case from an admission in a civil case. So if the matter is a civil matter, we tend to talk about admissions, and if the matter is a criminal matter, we tend to talk about confessions. It actually makes a lot of sense to use two different terms for the two different circumstances, because as you'll see as we progress through the material for this week, the rules pertaining to confessions in criminal cases are actually somewhat different to the rules pertaining to admissions in civil cases. So it does make sense for us to talk about admissions or confessions, because at least that way when we do so, you know which set of rules we're applying. An accused person may confess the offence in full, the classic "I done it, it's a fair cop," or they may confess specific facts which go to the offence. The classic case there is in, say, a rape case, where the defendant admits to the fact or confesses to the fact that there was sexual intercourse with the victim, but doesn't confess to any questions in relation to consent. In Australia, we have very clear authority, the statement of the High Court, that there is no doubt that a confession is admissible in evidence. So let's think about the rationale. Remember that right the way through this course, and in particular in relation to hearsay, we've talked about the fact that evidence law is all about balancing the two concepts of probative value and prejudice. Ultimately, the law's view is that an admission is so likely to have strong probative value that the probative value will almost inevitably outweigh any prejudice that could be caused to the person making the admission. More to the point, if the person who made the admission wanted to avoid the potential for that prejudice, they could do so by simply not making the admission in the first place. So if they're going to make an admission outside the court, in essence, on their head be it. There's also a presumption that a statement made by a person against those interests is likely to be true. So in other words, you're much more likely to say things in your normal life that are in your favour than you are likely to say things that go against you. So there's a presumption that if you're saying things that are contrary to your own interest, they're a little bit more likely to be true. Remember though, that's just a presumption, and that presumption can be rebutted because in normal life people do tell lies, and particularly among young people, I would say, there can be a tendency to say that they've done things that are slightly outrageous or slightly outside the rules, bending or breaking the rules, even when that might not exactly be the case. So the idea that a person is likely to be telling the truth when they say things that are contrary to their own interests is a pretty sound presumption, but it's only a presumption and it can be rebutted by other facts. Now, I mentioned a few moments ago that there are different rules in civil trials and different rules in criminal trials for admissions and confessions. There are a couple of reasons for this. The first is that obviously criminal cases require a higher standard of proof than civil cases. So we need to be a lot more sure in relation to criminal rather than civil admissions. We can accept a civil admission even if we're only sure that the admission was correct on the balance of probabilities. But to accept a confession in a criminal trial, the court has to believe that confession beyond reasonable doubt. So the additional rules for confessions are there to assist the court to make sure that it doesn't fall short of that required standard. And remember that the reason for that is that the person who's facing a criminal charge is facing the potential for criminal sanctions. There's an additional factor in relation to criminal confessions, and that is that confessions are often obtained by agencies such as the police, in which there is a substantial power imbalance between the person asking the questions and the person giving the answers. There are some communities where the relationship between the police and the community is one of such substantial imbalance of power that there may need to be very special protections in place to make sure that any confessions given by a person being interviewed by police are actually genuine confessions which are given freely and in an understanding of what the implications of the confession will be. So the court needs to be certain to the criminal standard of proof that the confession hasn't been manipulated or coerced and that it actually does represent the true confession of the charged person in relation to the offence. So it's absolutely vital when you're asked questions about admissions and confessions to think carefully about whether we're talking about a civil trial or whether we're talking about a criminal trial. Fair warning, guys, when it comes to the exam, there will almost certainly be a question on admissions and confessions, and if you apply the wrong set of rules, you are almost certain to fail that question. It is absolutely vital to understand whether you're dealing with a civil or a criminal case in this context. We're going to start with civil cases. We've already said that admissions in civil cases are any representation by a person which is made contrary to their own interests prior to the trial. We're going to break that down a little bit over the next short while, but I'll lay it out for you in summary first. First thing to know is that admissions in civil cases can be made in three ways. They can be made by words, they can be made by conduct, and they can be made by silence. It is not necessary in civil cases for admissions to be made voluntarily. Now that'll surprise some of you to hear initially, but it'll make more sense once we look at how that rule actually works. And finally, admissions are usually only useful against the person who makes the admission, but that's not inevitably the case, and we'll look at some of the exceptions to that rule as we work through admissions in civil cases. Now, before we get to the heart of admissions, I do want to take a few moments to differentiate between admissions and formal admissions. You'll remember that in previous weeks we've come up against this concept of a formal admission, and that a formal admission is a fact that doesn't need to be proven by evidence. It's a fact that the parties have agreed between them in writing will be treated as a fact for the purpose of this particular trial. It's very important not to become confused between admissions and formal admissions. So let's look at how to tell the difference. The first thing is that a formal admission always requires agreement between the parties. So both sides of the case have to agree, we will treat this fact as though it is true without anyone needing to bring evidence. An admission, in the sense that we're using the word in the hearsay rule, doesn't require agreement. It can be asserted by one party against the interests of another party. Second thing is, formal admissions can be positive, adverse, or neutral towards a litigant's case. Most of the time, formal admissions will be neutral. They'll be things that the parties don't want to have to waste time and effort in court arguing over, because they're neutral stuff that's not going to affect the outcome of the case. An admission, however, is always adverse to the litigant's case. Finally, it's almost always necessary, in fact I can't think of any circumstance in which it's not necessary, for formal admissions to be detailed in writing between the parties and then handed up to the court. No such requirement exists in the case of admissions. To tell the difference between the two, my hint is look for agreement. If you've got agreement between the parties to treat a certain fact as true, it's a formal admission, and that's not an exception to the hearsay rule. If you've got something that requires evidence, it requires to be introduced in evidence, then that's an admission for the purpose of the hearsay rule. Now, there's quite extensive notes about that from this week, and it's also described in the field textbook, and I suggest that you just take a few moments over that to make sure that you don't get too confused by the fact that we're using two very similar terms to describe very different aspects of evidence law, because if you get that one confused, it would be a very easy way to trip yourself up. So, having gotten that out of the way, let's start looking at admissions in civil cases. So these are, back to the exception to the hearsay rule, statements by people that are contrary to their own legal interests. Seems fairly obvious that admissions can be made by words. The classic case that we use for that is the case called Rumping and the Director of Public Prosecutions. It's a UK case. This is a case where a merchant mariner got drunk one night and killed a young woman by strangulation. It's heavily implied in the case, but not actually stated. This was after all the 60s, that the victim was probably a prostitute. He then took to his ship and tried to get as far away from the UK as possible, but he wrote a letter to his wife in Holland, and the letter said words to the effect of, "My darling, I've done something terrible, and you will hate me when you find out about it." When he was captured, it was held that the letter to his wife was effectively an admission that he had done something terrible, and it was then open to the Crown to show that the terrible thing that he had done was to strangle this victim. So this was held to be an admission by words. The words in Rumping were written down. The words don't, however, need to be written down to constitute an admission. Words, whether spoken or written, can constitute an admission. Another interesting thing about admissions by words is that lies can constitute an admission of a contrary fact. So, let's say somebody is taking a case against you in conversion because they say that you stole their car and didn't give it back. You tell them out of court that you weren't even in the city on that particular day, so you couldn't possibly have stolen their car. And they later find out that they later find evidence that you actually were in the city that day and that you'd lied about being off in Sydney or Melbourne or wherever you said you were. That lie, once found out, can constitute an admission of the contrary fact. So it is actually reasonable to go into the court and say, this person said they were in Sydney and gave that as their alibi for not stealing my car, but in fact they were right here in Brisbane. Now that on its own is not going to be enough to carry the day. That on its own is not going to be enough to make out that case. But it certainly doesn't help your opponent. It certainly enables the court to start reflecting on whether or not by telling that lie they might have actually been making an admission. The question is, by telling the lie, what were they trying to cover up? If you can work out what they were trying to cover up, the lie itself can constitute an admission. Pretty tricky one to make work, but it can be made effective from time to time. The next one is, and the next aspect of admissions by words is that they need not be given voluntarily. An admission can be induced by a promise or by a threat in civil cases. However, if an admission is induced by a promise or a threat, the witness is then entitled to explain those circumstances, and that may affect the weight which is given to the evidence. So, if you were to say to somebody, tell me the truth or I will beat you, and they then tell you what you want to hear, you would be entitled to go into the court and say, this is what he told me. But then the other party would be entitled to go into the court and say, I only said that because he threatened to beat me. And then it would be up to the court to determine whether the admission should be treated as, whether it should be given any weight in terms of the case or not. Personally, I reckon that makes a lot of sense because it means that we leave the court as the decision-making authority rather than trying to assert some sort of general rule to apply. Because in some cases, inducements, not so much threats, but certainly inducements might not be a bad thing. Inducements can sometimes just be part of normal social intercourse. So it might be, I will forgive you that debt if you tell me the truth. And that might be in some circumstances, might be a perfectly sensible way to do business. So you can see how if all inducements ruled all admissions out of play, things could get very curly. It makes much more sense to just put all of the circumstances in front of the court and let the court make its decision. Next thing I want to talk about with admissions by words is apologies. Apologies are a special type of admission, and they particularly relate to tort cases. And those of you who are from my generation or older, and maybe even those of you who are younger, you will find people telling you, if you get into a car accident, you must not apologise. Do not say you're sorry, because if you say you're sorry, you're accepting liability. Once upon a time, that was the truth. In all Australian jurisdictions now, the law has been changed so that apologies are no longer admissible in any civil proceeding to indicate fault or liability on the part of the person making the apology. So if two people are in a conflict and one person says, I'm sorry, that doesn't change anybody's legal position at all. The reason for this is that most of the time, people will say words like, I'm sorry, out of empathy, out of concern. I'm sorry can mean many things other than I accept the legal fault for whatever just occurred. So this is one of those occasions where it might have taken several decades, but the law eventually did catch up with normal human common sense. So an apology sounds an awful lot like an admission, but it's actually not an admission for purposes of law. Next, let's have a look at apologies by conduct. At admissions by conduct. Certain types of conduct can constitute admissions because they're taken as being effectively the same as representations. The case that we talk about is Singh and the DPP. This is a New South Wales case What happened was that Mr. Singh and a couple of his mates went to a nightclub with their girlfriends. Some other guys started dancing with their girlfriends, and there was an altercation. The whole lot of them got thrown out of the club, and they came across one another in the streets not too long afterwards, and another fight started. The police were called, and the police turned up. When the police turned up, Mr. Singh ran away from the police as fast as he could. When he was captured by the police, he then said that he had actually been trying to run towards the police because he was the victim, not the perpetrator of the fight. It was held by the court that the act of running away from police was in effect an admission that he had been the instigator rather than the victim of the fight that was going on. Now, put your hand up if you're a little bit worried by all of this, because I know I am. I have a couple of problems with the idea of admission by conduct. First is that conduct is very difficult to interpret. Now, Mr. Singh, as you can tell by his surname, is from an ethnic community, I presume a Sikh community, but it's not actually stated in the case. Now, let's say there was an irregularity with Mr. Singh's visa. Let's just say. That could provide a very good reason for him to be running away from police. Or let's say that he had come from a community overseas where police were not always fair-minded and professional. That might be a very good reason to run away from police. There could be 100 circumstances which could have caused him to run away from police. It's very difficult to definitively say this conduct was a representation of this fact. I just don't see it. But more importantly, let's remember what we're doing here. We're looking at an exception to the hearsay rule. Now, hearsay occurs when you have a third-party representation out of court. What I say is, if somebody's actually conducting an act and you observe that act, it's observation evidence. It's not hearsay evidence at all. And if it's not hearsay evidence at all, then why on earth would you need an exception in order to introduce it into evidence? So the law tells us that admissions can be made by conduct, but from my personal observation of the way the law works, I really don't think this is something you're ever likely to come across, but it's something that you need to know is out there. The third type of admission is an admission by silence. In civil cases, there is no right to silence. In civil cases, the failure to say something can actually constitute an admission in relation to whatever it is that you failed to say. So if you're under a duty to speak and you fail to speak, then the fact that you failed to speak can be held against you. There's a couple of cases that I've pointed to understand admissions by silence. The first one, Young and Tibbetts, I don't really want to go into. It's a fairly boring land law case, but it's worth having a read, at least in part. Have a look at it because it sets out the rule very neatly. The case that I would rather talk about in relation to admissions by silence is a case called Thatcher and Charles, which was a 1960s case that happened here in Australia. Thatcher and Charles arose from a situation in a community housing estate where a man had a reputation for driving dangerously and riding motorcycles dangerously, including in the vicinity of children. Eventually, the inevitable occurred, and he ran down one of the children and injured the child quite badly. In the immediate aftermath of the accident, the mother of the child said words to the effect of, "Why did you do it? We've been telling you for ages that this was going to cause an accident the way that you drive." He was silent in response. Now, it was asserted by the plaintiffs that his silence in response was an admission that he had in fact been told that his driving was dangerous, and that he had in fact been told that he was likely to do harm to some of the children if he continued to drive in that way. The court disagreed. The court said, yes, it is entirely possible to make an admission by silence, but before we will accept an admission by silence, the surrounding circumstances must make it very clear that we're drawing the right inference. In this case, they said, looking at it from the respondent's point of view, he's just run down a little girl. She's being loaded into the ambulance, she's being taken off to the hospital. For all he knows, he may have just killed a little girl, and he gets accosted by the little girl's mother. There are many, many reasons to keep one's mouth shut in those circumstances. And it's just about impossible to draw a really clear inference between his silence and an admission of the things that were being asserted by the mother. So this is one of those rules that you can understand at best by looking at circumstances where it doesn't work, rather than looking at circumstances where it does. So admissions can be made by silence, but the inference has to be so clear that the court is almost inevitably led to the conclusion that the silence was an admission. So, who is bound by an admission? Most of the time, the only person who can be bound by an admission is the person who makes the admission. And this makes sense because the initial definition that I gave you was an admission is a statement by somebody against their own interests. So it hardly seems fair to be able to admit something against someone else's interests. You might be called to give evidence of whatever it is that you've admitted, but that would be third-party evidence. It wouldn't be the same as an admission. There are some circumstances in which admissions can be binding on other parties. The first one is an admission can be binding on a successor in title. Now the case here that we'll look at, Nowell and Palmer, makes this exception really clear. In Nowell and Palmer, a husband and wife made mutual wills. Now, for those of you who haven't done succession law yet, mutual wills are basically a contract between two parties, usually a husband and a wife, where each party agrees to write their will in specific terms. So the husband and the wife both agree what's going to happen to the property between them, and they both write their wills in those terms, and they promise not to change those wills. In this particular case, what happened was that the husband and wife made promises which would mean that when the second one of them died, the mutual estate would all go to the mother's daughter. What happened was that the mother died first, and then her husband remarried, and he tried to change his will so that his entire estate would go to his new wife. That, of course, would have left the daughter without any share of the estate that her mother had built up through her mother's lifetime, which doesn't seem real fair. Ordinarily, succession law would have said, well, too bad, the husband owns the stuff and therefore he can leave it to whom he likes. But in this case, there were mutual wills, so there was a promise, a legally enforceable promise on the part of the husband that he would not change his will. He admitted in conversation with people before he died that he had made these mutual wills, and he admitted that he understood its context. And what that meant was that even though probate had been received and the title had passed to the new person, that new beneficiary was considered to have been bound by his original promise, and his admission was held against her, and she had to give up title to the property. So you can see that in that case, an admission that's made in relation to property kind of affects the property rather than the person. So if the property goes from one person to the next, the effect of the admission may well travel with it. The second type of admission that can be made by a second party is an admission by an agent. Now, if you think about it, those of you who've done corporations law, or those of you who have any concept of how companies and corporations work, will know that a corporation is a legal person. So a corporation has most of the rights of a natural person. But a corporation, of course, can't speak on its own behalf. A corporation must speak through the agency of people. So if the chief executive officer of a corporation makes a statement which is contrary to the interests of that corporation, it's quite likely that the CEO was acting as the agent of the corporation and so his or her admission would be able to be held against the corporation as a natural person. So that makes a reasonable amount of sense. The final thing about admissions is, strangely enough, you don't always need to have personal knowledge of the things you're admitting. The case that we look at here is a case called Smith and Joyce. It's a 1950s case that arose from circumstances in an abattoir. In this abattoir, they were going through the process of slaughtering cattle. Now, apparently, I don't know anything about this except from having read the case, but apparently, in order to slaughter a cow safely, it's necessary to insert a rod into its spinal column after it's been initially killed to depress any latent nervous activity, so that when the beast is being skinned and butchered, it doesn't have muscle reflexes that result in harm coming to people. Well, in this case, the abattoir worker failed to carry out that process, and then another abattoir worker approached the carcass with a knife, and there was a nervous reflex in the limbs of the animal, and the knife was flung out of his hand and did severe damage to his face and head. And so he sued in the equivalent of a workers' compensation jurisdiction. What happened was, in the meanwhile, the circumstances were reported to the foreman and manager. And the manager said words to the effect of, Smith should know, or Joyce should know better than to have tried to butcher the animal without sticking and fiddling it, as they say. So he was admitting that it was normal practice to have carried out this procedure, and he was held to have effectively been admitting that the practice hadn't been carried out in this case. Even though he wasn't there on the floor, he was going on the basis of what was reported to him by his staff. So he had no personal knowledge, but he had a knowledge on the basis of what was reported to him, and he made an admission on that basis, and that admission was held to be evidence. I have a real concern about this, because you'll remember that last week we spoke about the concept of first-hand and remote hearsay. This starts to sound very much to me like using remote hearsay as evidence, because what we're saying is something happened because person A admitted it, because person B told them that it had happened. Now, if that's not remote hearsay, then I'm not sure what is. They do allow this form of evidence to be admitted, but it's very rare for it to be given compelling weight. And that's probably because of just the sorts of concerns that I'm talking about. It's pretty rough, isn't it, to have a verdict come down against somebody on the basis of an admission which was made by somebody who didn't actually have personal knowledge of whatever they were admitting in the first place. So you don't need to have personal knowledge, but the weight of the admission is very much going to depend on whether or not the person does have personal knowledge. So that's admissions. Let's switch now to confessions. Confessions, as we said earlier, are admissions in a criminal law case. Confessions have much tighter rules because the person has to be convicted on the basis of beyond reasonable doubt, and they're facing potential criminal sanctions. A defendant may be convicted on the basis of a confession out of court, and they may be convicted on such a confession even if they recant from their confession and plead not guilty in the court. So it can be introduced in evidence and it can be compelling, but there's a bunch of rules that have to be followed. The first one is the confession must be voluntary. Now, this is different to what we heard about admissions, where admissions don't necessarily have to be voluntary. A confession does, particularly when the confession is made in the presence of police. So the rules are the participant must be involved in the interview voluntarily. They must not have been offered an inducement to confess. They must not have been subject to unreasonable oppression or threats. and they must not have been subjected to trickery. Any of those things will make a confession completely untenable. Some of you may have heard the story, I've written about it in the notes, a story from the 1970s about a jurisdiction in the US. I always thought this was an urban legend, but it turns out to be true, where they connected some wires from a colander to a photocopier and put the colander on the interviewee's head and told him it was a lie detector test. And they had a piece of paper on the platen glass of the photocopier which said, "He's lying." And every time the police didn't like the statement which was made by the interviewee, they pressed the button on the photocopier. Remember, this was the 70s, and we thought photocopiers were space age back in the 70s. Every time they pressed the button, it spat out a sheet of paper that said, "He's lying." And the criminal believed that he was genuinely being interrogated in the presence of a lie detector and promptly confessed. As I say, this was always assumed to be urban legend until sometime in the 1990s, when the judge who actually presided over that case wrote a letter which made it clear that it actually had happened just that way. That, of course, is trickery. And so in Australia, a confession obtained in that sort of way would not be effective. In the same way, the plea bargaining systems that you see on your CSI Miami type shows on the television, that just doesn't happen in Australia, because you cannot offer somebody an inducement in order to get them to confess. Naturally, there are benefits associated with pleading guilty, but in our system, you're only meant to plead guilty if you actually do have guilt to whatever you're pleading. And the plea bargain process doesn't happen in anywhere near the same way that it happens in the United States. So the first point is that for a confession to be a confession, it must be given voluntarily. Second thing is that we still have a right to silence in Australian criminal law. The right to silence comes out of two rules. First, the privilege against self-incrimination, and second, the requirement that confessions be voluntary. So if you were required to answer questions that would tend to incriminate you, then both of those privileges or both of those requirements are broken. The way it works is that a defendant is entitled to remain silent, and they are entitled for that silence not to be held against them. Okay, so no presumptions can be drawn from the fact that they're remaining silent. Some of you will be aware that in New South Wales just recently the right to silence has become controversial, and there's been suggestions by the Premier of New South Wales that the right to silence should be removed. It will be interesting to see how that plays out, but as it stands, certainly in Queensland, there is a very clear right to silence which is enshrined in the Police Powers and Responsibilities Act 2000. Now, there's one slight exception that we need to talk about in terms of confessions being voluntary, and that is confessions by co-conspirators. I'm presuming that everybody here has done criminal law, and that you remember way back in first year when you talked about criminal law, and you'll remember that there's a difference between simply being two people co-accused and two people who are accused of being part of a conspiracy. A conspiracy is a common enterprise between several people to jointly commit criminal acts. So they've formed essentially a criminal syndicate, and they've planned something out together, and then they've executed it as a team. If that occurs, and one of the conspirators gives a confession, that confession can be held against everybody who was part of the conspiracy. But in order to do that, the prosecution must show that the defendant actually was part of a conspiracy. So, if there was a conspiracy, if there was a group of people being led effectively by one mind to carry out as one organisation a criminal act, then the confession of one person to having been involved in that process can be held against everybody else. Next rule we need to look at for criminal confessions relates to judicial discretion. You might remember way back in topic 2 we talked about judicial discretion. We said that judges there's 3 bases on which judges can exclude evidence that would otherwise be admissible. The first is if it was collected in such a manner that its use would be unfair. The second is if its prejudicial risk outweighs its probative value. And the third is if it should be excluded for reasons of public policy, such as that it was collected unlawfully or that its release would be contrary to the public interest. These discretions are often applied in relation to confessions, and they're applied almost instinctively. If a judge thinks that there's something fishy about a confession, if it just smells bad, it just doesn't seem like cricket, then the judge will be able to use one of these judicial discretions and exclude the confession. There's a great case on this, and I urge you to read it and have a look at it. The case is called The Crown and Swaffield, Pavich and the Queen, or commonly just referred to as Swaffield and Pavich. Now, Swaffield and Pavich was actually 2 separate cases, but they were heard together in the High Court. The High Court, if you haven't come across this before, the High Court does this from time to time. If they have 2 or 3 cases on the books that refer to almost the same point of law, they'll hear the cases together, go through the point of law together, and then make one judgment. So we've got two different sets of facts. Now, in the Crown and Swaffield, what happened was there was an undercover police officer who was investigating a drug matter, and in the course of that investigation, without revealing himself to be an undercover police officer, he had a conversation with Swaffield, and he had decided, the police had decided that Swaffield was going to be charged in relation to several arson offences. So the undercover police officer started asking Swaffield about these arson offences, and Swaffield confessed. In the second case, Pavich and the Queen, Pavich's mate, Pavich was accused of murder. Pavich's mate went and had a chat to him whilst wearing a police wire. Now, should neither of these confessions be upheld? What the court found was that in Swaffield's case, the confession should not be upheld. And the reasoning, in short, was that once the police had decided that he was guilty of a crime, the police were under a responsibility to arrest him, caution him, and make sure that any confession that he gave was consistent with the rules around police interviews. That it's not good enough to simply keep plugging away for information even after they've decided that a person is going to be arrested for a crime, before they give that person notice and give that person an opportunity to protect their own interests. So that one was ruled out. However, in Pavich's case, the court was perfectly happy with the confession, because the court said Pavich was not interviewed by a police officer. Pavich was talking to his mate. Pavich had no reason to believe that he was subject to investigation, and at the time that Pavich was talking to his mate, the police hadn't decided to charge him. The police were still looking for evidence to find out whether Pavich was actually their man. So it wasn't a set of circumstances where the police had created a situation to entice a confession so that they didn't have to bother doing it in interviews. So you can see that the judges are able to make really quite fine judgments, really quite fine uses of judicial discretion to say essentially, well, we just don't think this one's right. What that, of course, leads on to is the idea that we need to be very careful with how police obtain confessions. In Queensland, we have the Police Powers and Responsibilities Act 2000, and beneath that, we have the Police Powers and Responsibilities Regulations 2000, and within those regulations, there's a Responsibilities Code, which sets out the procedures that police have to comply with whilst questioning people. Any failure to meet the substance of those responsibilities, so not that they can't find loopholes, even if the police are meeting the letter of the law, but they're failing to meet the substance of those responsibilities. If they fail to meet the substance of the responsibilities, it's likely to render a witness statement or a confession inadmissible. So the police have responsibilities that they must meet, and these are things like allowing people the opportunity to obtain legal representation, or not holding people in cells for an unreasonably long period of time without access to water or food or anything like that. There are specific requirements in relation to the detention and interviewing of Indigenous people. So if the police don't follow these rules, then the confessions that they take will not be admissible. Finally, I've just mentioned special requirements. There are a bunch of special requirements in relation to 4 different types of people in in Queensland. The first is children. The second is persons with a mental illness, and that's whether temporary or permanent. Third is Aborigines and Torres Strait Islanders, and there are a bunch of requirements there, primarily arising from recommendations of various royal commissions over the years. And finally, Queensland is unusual because Queensland includes laws that have additional requirements for confessions by people who are heavily intoxicated by drugs or alcohol. Now, in most other jurisdictions in Australia, a confession can be given by a drunk person provided they reach a certain basic level of understanding of what's going on around them. In Queensland, the bar is set slightly differently. If a person is insufficiently sober to be able to properly attend to their interests, then they can't give a confession. So essentially, the police are best off to wait until that person is reasonably sober rather than trying to entice a confession out of them while they're still intoxicated. So what you can see at this end of the lecture is that there really are quite a few differences between admissions in a civil case and confessions in a criminal case. There's a bunch of extra rules that have to be met before a criminal confession can be used to apply a criminal sanction to a person. So during this lecture, we've learned about the definition and the nature of both admissions and confessions, and why they are an exception from the hearsay rule. We've learned that civil admissions can be made by words, conduct, or silence, and that you don't need to have direct personal knowledge to make an admission. We've learned that admissions are generally only binding on the person who made the admission, but there are exceptions for succession in title and for agents. That in criminal cases, confessions have to be voluntary. The person making the admission has the right to silence, and judges retain the discretion to exclude unfair admissions, and unfair admissions will include those which are made in breach of the police responsibilities under the Police Powers and Responsibilities Act. So there are a bunch of rules there, but they do result, in my view anyway, in most cases, in admissions and confessions that come before the court, in exception to the hearsay rule, being reasonably reliable and assisting in the process of justice. This week we're going to look at a confession which was completely unreliable and completely didn't assist in the process of justice. I'm going to ask you to watch some scenes from the movie In the Name of the Father, which was about the Guildford 4 pub bombing in the United Kingdom. Just a fair warning for those of you who are sensitive to such things, the scene is quite harrowing to watch, and there is near continuous use of profane language. So if you are offended by that sort of material, you may wish to give this one a miss. But the nature of the scene is such that the profanity is not gratuitous or unreasonable in the circumstances. But please do be aware that material is in there. I hope it does put this week's lecture into context, and that the questions are helpful, and I'll look forward to talking to you again next week.